5 minutes.
Thank you very much, Mr. Chairman. Mr. Sandredden, my understanding is that even after a non-attainment area is redesignated as being in attainment, it is still subject to EPA oversight and maintenance plans for an additional 20 years. Can you explain if I'm right on that understanding and how that works?
That is correct. As I've said, we have made major progress over the years to meet the standards. We used to be non-attainment until 2010 for PM10, and we came into attainment. But what happens right after that, you write a maintenance plan, which is essentially identical to a state implementation plan. You still have to maintain all of those regulations that you had in place. If all of a sudden you end up in, not meeting the standard or various new requirements that kick in. So it's a never-ending process in terms of maintaining the controls, and you will never have an opportunity or a circumstance where you can roll back any of the existing measures that you have put in place to come into attainment.
All right, so let me see if I can clarify and go from there. And I see some others, particularly Dr. Shaw, nodding his head. So you've now hit the attainment, and you said you have to put a maintenance plan in, which to me makes some sense. But then you said you have to keep all the controls. Does that mean that you can have a new plan that says here's what we're going to do to maintain, or do you have to keep all the controls in place that were in place, even if there's no evidence that a particular control was relevant to bringing you into attainment?
Essentially, when you put a maintenance plan, you cannot roll back any existing regulations that you had. If there is a potential scenario like that, that would be the case. That is exactly as you describe it. But given that we have 8 other plans to meet with, there's always regulations that are needed to meet those new requirements, and they can also be used to satisfy the existing maintenance plan.
And I just want to make sure that I'm not miscommunicating, because my wife accuses me of doing that sometimes. So as I understand it, even if there's evidence that one of the plans had nothing to do with you coming into attainment and may just be superfluous, you still have to maintain that particular component?
Yes, there is a general legally accepted provision that once a particular control measure becomes part of a state implementation plan, you can never relax that regulation.
Okay. Yes, sir. And my time's run out, so if you could be brief.
I'll be quick.
You disagree?
I disagree. I think, first of all, the way EPA has addressed the standards of clean data determination, and a lot of areas get redesignated to attainment without having to develop a maintenance plan. So there isn't another way of getting to where the requirements don't carry over. But maintenance plan development, the plan is, it gives you the flexibility to show that you're achieving the reductions and maintaining those reductions by mixing and matching. We can do that under our attainment plan strategies. I can take a measure out, but I have to replace it with something else that gives me that reduction so that I can show that attain.
Okay. So the distinction would be, however, if you're taking something out that does nothing, but you have to put something back in, based on what I'm hearing from both of you, but it's a legalese thing, I may still have to put something back in, even if I don't think it does any good, if I'm taking something out that doesn't do any good, because you have to replace it with something that does the same type of thing. And so, and we could debate this all day, but it sounds like to me that while there may be a slight distinction between what the two of you are saying, it's basically the same. You've still got a plan, you've got a component. You can't just eliminate that component if it turns out to be not accurate. I've got to move on because I do have another question I want to get in, and I don't have much time left. Mr. Sandredden, again, when the EPA revokes a standard, do states or localities continue to be subject to obligations under those standards?
Right. I looked at Mr. McCabe's testimony, and that was cited as one of the streamlining measures in the Act currently, that if you revoke a standard, hey, no harm, no foul, you can move on. I have to say, first of all, before I comment on Ms. McCabe's testimony, she has always been gracious, generous with time and creativity in helping us do everything that we need to do, and we've worked well together with her and with EPA. And in fact, I was happy that in her testimony she did not object to a couple of things that are in this bill that we had advocated for, the contingency measure elimination for extreme areas, and also economic feasibility with relation to RFPs. But on that particular issue relating to revocation of standards, I think it's a bit misleading to say when a standard goes away, you don't have to do anything. As I'm sitting here before you, June of this year, we have to write a plan for the 2008 ozone standard, which is about to be revoked. We have a plan in place actively for the 1997 ozone standard. We still have a plan in place for the 1979 ozone standard. Everything that is in the Act remains in place when you revoke a standard. The only thing that goes away is you can do a new transportation conformity budget. Otherwise, every other requirement stays in place, and to somehow say revoking the standard takes away requirements, it's absolutely incorrect.
I appreciate it. I yield back. That's the end of my time. Thank you, Mr. Chairman.
Chair recognizes the gentlelady from California, Ms. Capps, for 5 minutes.
Thank you.